Joining me now for more on the president's assault on the rule of law, Congressman Jamie Raskin, Democrat of Maryland. He's a member of the Judiciary Committee that has oversight over William Barr's Department of Justice, has been a chief advisor to the Democratic caucus throughout impeachment and on oversight. Let's talk about from where you sit as somewhat of a principal. It wasn't your personal subpoenas. You don't chair a committee that subpoenaed these financial records. But as a member of Congress, as part of the team that sort of thinks about where Congress stands with relation to the president, your reaction to today's rulings?
Well, the Vance decision, the prosecutor's decision was great. And it was an emphatic endorsement of the rule of law as we've always understood it, which is that everybody owes the government his or her honest testimony and his or her documents when there's a trial going on, and nobody's above the law, including the President of the United States. And so I thought Chief Justice Roberts wrote a really authoritative and magisterial opinion, and they preempted a lot of the self-pitying, whining diatribes sure to come from Donald Trump complaining about it, going through every president that has accepted this principle, going back to 1807 in the Aaron Burr treason trial, when Burr moved for a subpoena of Thomas Jefferson's records and got them. And Chief Justice Marshall said that the president does not stand exempt from the Constitution and from the due process commands of the Bill of Rights for other people. So we all owe the sovereign our honest testimony. It was a relatively simple case. The only thing new about it was that it was a state government that was issuing the subpoena, state prosecutors, and we know how much Donald Trump has contempt for the states, and they thought that that was ridiculous, that he could be subjected to the burdens of doing this. But the court said it was exactly like the burdens that were allowed against Bill Clinton and Clinton versus Jones. Now, as for our case, the Mazars case, we feel pretty vindicated. This is pretty much the best we could have gotten out of a court which still leans heavily to the right through all the gerrymandering and the refusal to even have a hearing for my constituent Merrick Garland when he was nominated by President Obama. It's the best we could have gotten because it was another obvious case. Of course, Congress should be able to subpoena what it wants from the president. We are the lawmaking branch of government, what James Madison called the predominant branch of government. And we need to obtain the knowledge and information that we seek in order to govern and in order to legislate. But as you were suggesting, I agree with your analysis. They wanted to slow the whole train down so that perhaps, what the conservatives bought out of the situation in the 7-2 ruling was this nebulous, non-exhaustive four-factor test about the necessity of Congress getting the information, the narrowness of the subpoena, how substantial our evidence is for needing to get it, which makes it sound like we're an administrative agency. And I consider that a real affront and insult to legislative power. And then you balance all of that against the burden on the president, which they did quickly dismiss, saying we found numerous times before that the time of the president and the burden on the president's attention is not justification for him not turning over documents that are subpoenaed by our justice system.
I just want to note this. You don't have to respond to this, but there's something truly darkly comedic about the president's lawyers being before the Supreme Court saying it is too burdensome on the man's time and his attention for his financial his accounting firm to turn over its records while the president is like live tweeting 3 a.m. Fox programming. As if this is a man who's just so consumed by his work that, like, how dare you? And they made this argument with a straight face. Like, I mean, obviously it's the presidency as an institution, not this president, but it's a little hard to take with this guy.
I think that Chief Justice Roberts himself took a glancing oblique shot at precisely that humorous point when he said, as Chief Justice Marshall observed in the Aaron Burr case, the duties of the president might be intense, but they're not unremitting. And that would be the mildest thing you could say about Donald Trump, who does no work at all and spends the whole day sitting on his bed tweeting out in response to things he watches on Fox News. Yeah. Forgive me for mentioning your competition.
So anyway, I probably find a few minutes.
It was a good day for the rule of law, Chris. But we're in the end days here of a nightmarish, authoritarian, right-wing, predatory presidency. He's getting increasingly desperate. When you were saying there was one phenomenon like he can't bully, and it's COVID-19, that assumes that he considers COVID-19 an enemy. And I'm not sure he does anymore. I think he believes that COVID-19 and the rampant spread of the disease around the country is his best bet for voter suppression and being able to manipulate the electoral process. And so I don't think he considers it an enemy anymore. And he's certainly not doing anything to try to stem the tide of the disease.
Well, I don't make a lot of predictions, but I will make this one, that this is not the last time we will hear from the Supreme Court on important balance of power constitutional issues in the year of 2020. Congressman Jamie Raskin, who is one of the sharpest constitutional thinkers in all of Congress, thank you so much for your time tonight.
My pleasure, Chris.